Let us begin. As I said in my earlier note, we must abandon our beloved Socratic method for now, but we will still cover the information you need to have to be fully armed as practitioners of criminal law, or at least to pass those upcoming exams. At the outset, I want to review the intoxication defense, focusing on voluntary intoxication, the most common defense in this area, and at the end we'll touch upon involuntary intoxication, much more rare. Of course, intoxication is an excuse defense. Intoxication in the mental state and insanity defenses all raise mens rea issues, and this transition begs the question of why, if alcoholism is a disease, we treat it differently than those other diseases. And again, mens rea is at the core of this discussion. We discussed this in homicide. As you remember, I'm sure, in Pennsylvania, voluntary intoxication can be used to reduce first-degree homicide to a lesser degree of homicide. It is indeed statutory. Let's look at the historical past of the intoxication defense. Pennsylvania has this harsh treatment, and that harsh treatment has deep roots. Blackstone made intoxication, voluntary intoxication, an aggravating condition of a criminal charge. Instead of a cause for mercy, he made it an enhancement. This harsh treatment has prevailed, only softening barely as we begin to treat intoxication and alcoholism as diseases. In many jurisdictions, this distinction, this more liberal approach, is based on the difference between specific and general intent crimes. Specific crime, as you recall, has a specific intent crime, as you recall, has two intents. Burglary is a good example. Entering the dwelling house of another under the cover of darkness with the intent to commit a felony therein. There are two intents, the first one being the introductory language, and the second one with the intent to commit a felony therein. So these specific intent crimes generally reveal themselves by virtue of their language. And again, we see that the specific versus general intent distinction is what's critical. Remember, PA limits this to homicide, reducing first degree to a lesser degree. You should reread that section of the Crimes Code, section 308. It is in the culpability chapter. Speaking generally again, here's another way to state the general and specific distinction. Voluntary intoxication is a defense if it negates the defendant's capacity to possess the crime's required mental element. General intent crimes cannot be avoided by an intoxication defense. Strict liability crimes cannot be avoided by an intoxication defense. There's a little limitation here. You probably won't come across this much, but there are cases like this. The accused must have formed the intent while intoxicated. Thus, one who forms the intent and then drinks to build up the courage to do an act has no defense. Here it is again. Pennsylvania is not alone, as we learn by this slide. It is joined by Virginia. A common thread in both cases is the ability to reduce first-degree homicide to a lesser degree, regardless of whether you're in Pennsylvania or one of the other general specific intent jurisdictions. It makes sense if you think about the emphasis on premeditation and the deliberate nature of first degree. For the most serious crime and the most serious punishment, we have set a higher bar. So regardless of the test you use here, the ability to reduce first degree to a lesser degree is a common thread. Here's a good example of the mens rea issue under the Federal Crimes Code, which recognizes that distinction, that modern distinction between specific and general intent crimes. As you recall, this was an assigned case in our materials. In its holding, the court merely said that the defendant should have been permitted to introduce voluntary intoxication evidence at trial, since the federal courts recognized this distinction between intents, and the trial court had prohibited the defendant from introducing evidence of voluntary intoxication. You can see here that the MPC is even more liberal. It broadens the consideration of voluntary intoxication as a defense, evaluating whether it negatives an element of the offense. This is a trend that may be the beginning of a broader reevaluation in light of alcoholism being deemed a disease and not just a weakness or the exercise of extremely poor judgment. Now, let's talk for just a minute about involuntary intoxication. Involuntary intoxication is broader yet in many jurisdictions in terms of a defense, as it should be. The defense can apply involuntary intoxication to specific intent crimes, obviously, but also to general intent and even to strict liability crimes, theoretically. It is not explicitly adopted in Pennsylvania, but it is sometimes argued, even though it is rarely argued successfully. In Pennsylvania, this is an actus reus determination as opposed to a mens rea determination. It would focus on the lack of the voluntariness of the act. So here are the four different kinds of involuntary intoxication that have been recognized. There is coerced intoxication. That is a duress defense. We have that in our crimes code, and it might be the go-to defense that one would use. We have pathological intoxication. That means that a person has an unknown susceptibility to a particular substance, and then there is an intoxication by innocent mistake situation in which the substance is unknown, and finally, unexpected intoxication resulting from the ingestion of a medically prescribed drug, and someone perhaps cannot be charged with anticipating how every drug will affect them. The duress defense has always been an option in PA, not just here, but in other areas, as we have studied. It is fact determinative, and again, any of the four would be an acceptable argument in Pennsylvania. They are fact-driven and go to actus reus more so than mens rea. Voluntariness of the act would be the focus, but this defense lacks any statutory authority. Again, you would have to simply convince a court that in terms of fairness and the lack of actus reus, your client is innocent. Now, that's it for our brief review of intoxication. Next up, in Section B of Unit 10, we will discuss the history of the insanity defense and other mental illness defenses.